Hey, Keith Davidson, how are you?
I'm doing good. How are you, Stuart Albertson?
I'm doing great. It's been a while since we've done an Ask to Lawyers, and I know people have been asking what happened to us. So I need to ask you what happened to us.
We've been busy. we've been just a touch busy lately. Yeah, a lot going on. A couple new cases came on board, and yeah, we've just been completely slammed. And of course, I'm here in the studio while Stuart, you're somewhere else in the world.
I'm somewhere else in the Pacific Northwest. I'm not going to tell anybody because I don't want anybody to bomb my location. But
Yeah.
anyway, I'm up here in the beautiful Pacific Northwest and headed back on Friday to sunny San Diego.
Yeah, which is actually a touch. Well, it's what in San Diego we would call it hot because it's 82 degrees. But I used to live somewhere, and so did you, where
Yeah,
it would easily get 110. So 82 is laughably not hot. But
yeah,
anyway, it's a hot day in San Diego. Put quotes around that.
yeah. Hey, a shout out to one of my favorite podcasters, Lauren. She's here. The Court of Random Opinion. Always happy to see her. I'm kind of a sleuth when I watch her stuff. I don't comment or anything, but I really enjoy the stuff that she puts out.
Yeah,
Um,
same here. I watch Lauren a lot, but I don't participate, but I do enjoy her show.
so before we jump in, we're kind of, some of this stuff may be old news to most of the jury pool as we're going through it, but it's stuff that has interested us in the last few days or last few weeks in this Baldoni lively saga that continues. But first of all, I just wanted to talk a little bit about how we view these cases as lawyers, Keith, from a advocacy standpoint and from an unethical behavior or unethical conduct standpoint. And maybe you want to, do you want to just take a stab at what we're talking about there between being a zealous advocate and being a lawyer that's maybe crossing the lines and doing things you shouldn't be doing?
Well, at times there's some bright lines between what's ethical and not ethical, and obviously you don't want to cross those lines, and you want to be ethical in what you do. But within the world of zealous advocacy, we take an oath when we become lawyers where we promise to zealously advocate for our clients. And there are times when you might do things or, file things with the court, which we'll talk about in a minute, where maybe you don't make the judge very happy, or you do things that in hindsight maybe don't look to be such a great idea. But in the moment, you were being a zealous advocate, and it's not always easy to know where that line is crossed. And it's really not our job as lawyers to, I guess, you want to work well with the judge, but it's not really our job to make the judge happy. It's our job to be a zealous advocate. And so, yeah, it's a delicate balance, I guess, is the best I could answer that. I don't feel like that was a great answer, though, Stuart. So maybe you could give us a better understanding of what that would be.
Well, we've got two examples that we can look at today. And the first one would be the Doe only lawsuit that was filed in New York State Court by the Manatt lawyers on behalf of Blake Lively. And this was back in September of 2024. And then you've got the letter that was sent to the federal court here, Judge Lyman's court, by Bryan Freedman, where he points out that he has an unnamed source that gave him some inside information. And it's all very exciting information that he received. And he is going out of his way to inform the court as to this phone call, multiple phone calls he's had with this insider regarding a threat that's being made by Blake Lively. And this, of course, is without, naming the source. Nobody can question the source and determine if this is accurate or not. But you've got two lawyers. You have this Miss Katze, who's a lawyer with Manatt. And by the way, Judge Liz did a pretty thorough video on this Doe only lawsuit, which many are calling the sham lawsuit, but it's the Doe only lawsuit. And Judge Liz, I thought, was overly harsh on Samantha. I think her name's Samantha Katze. She's an attorney at Manatt. And the reason I think that Judge Liz was overly harsh is because Judge Liz is using information she currently has today to grade Samantha Katze and Manatt and the legal team for Blake Lively in September of 2024 when they filed that Doe only lawsuit. And I had pointed out at one point that I thought the Doe only lawsuit was a beautiful chess move if it was done ethically, if it was done well. And I read some comments, and I had to quit reading the comments because I was told I was an unethical lawyer, so I finally just had to stop. But there's that going on, right? So, but then you turn to Bryan Freedman, and Bryan Freedman, last week he's sitting there at his desk, and he's a really smart guy, and he's a good lawyer. I have nothing bad to say about him. And he's got this letter, he's got this juicy information that he wants to tell Judge Lyman. Really, he wants probably to tell the press. He probably wants people to know what's going on. And he has to file this. And so the question for both of those filings, the Doe-only lawsuit and Bryan Freedman's letter to the court that ultimately the court struck from its docket, was that zealous advocacy on behalf of their clients, or was that crossing the line? And, I think there's some rich discussions we can have on both of those filings.
I think so too. And I think it depends on what did you know and when did you know it. And we talked about that with the, lawsuit, the sham lawsuit, whatever you want to call it, where the subpoena was issued. And of course, you and I spent the better part of, a month and a half questioning where the heck did this subpoena get issued from? We finally know where it got issued from. So was it an aggressive move that was, within the realm of ethics, but in hindsight doesn't look great? Or was it just out and out unethical? And I think it comes down to what did they know and when did they know it? As far as what Bryan Freedman's doing, if he's filing something with the court where he's exposing a bunch of facts, and a lot of the facts he stated in there was on information and belief when he filed his filing with the court, but he files it without attaching it to any motion. It doesn't appear to be any outward reason for filing it. Is that zealous advocacy, or are you going too far? And I guess we'll see what the court said about that. But I guess the difference in my mind with what Bryan Freedman did is at least he was being a zealous advocate. He wasn't necessarily trying to get information without giving notice to other people, which is what that subpoena was all about on the Lively side. But that doesn't necessarily mean that what Bryan Freedman filed here was appropriate. And I think ultimately...
What about Samantha Katze? Was she being a zealous advocate for her client and fighting hard for what she knew in September of 2024? Or was she crossing any lines from your viewpoint, from what we know about the case today?
Well, she definitely was being a zealous advocate. Now, the question becomes, was she doing something that was improper or even unethical? And that, again, goes back to what did they know at that time and when did they know it? So if they knew at that time everything about what those text messages said from that they were going after from Jen Abel's phone that was in the possession of Stephanie, I think if they knew what that was and they were trying to get it without alerting anybody, I think that's a problem. I think that's when I would say you've gone too far. You've crossed a line. If they didn't know that and they're just thinking that, we don't know what's going on here, and I don't know if we want to file a lawsuit or not, because I don't even know if somebody's trying to harm us. I've just been told something by somebody, but I have no proof of it. I have seen no texts. I'm completely in the dark. If that was the state of affairs, then I think it was an interesting move and probably being a zealous advocate of filing that in order to get those text messages. I personally find it hard to believe that the Lively party hadn't seen the text. I just personally think that they saw the text. But that's an assumption on my part. I don't have any evidence that would back that up. That's just me thinking through it and making what I think is a logical presumption. So it's but you can't base legal theory on presumption. I mean, we as lawyers, we need admissible evidence. So it's an impossible question to answer. I cannot answer with 100% certainty if it crossed the line or not. It could have. And in my opinion, I think there's a better chance that it did, but it could not have if they didn't know anything.
Okay, and then the question, turning from Samantha Katze, who probably didn't realize her name would be talked about this much when she started the year. Let's turn to Bryan Freedman, who is much better known than Samantha Katze. And he obviously made a decision to file a letter with the court. And we're going to talk a little bit about the court's response to that. And if the court's response was not very good for Bryan Freedman. But my question to you, Keith, is what would have happened if it had been Blake Lively's attorneys who had filed this letter that Bryan Freedman filed, and the court had hammered Blake Lively's attorneys the way that Judge Lyman hammered and publicly embarrassed and shamed Bryan Freedman for filing this letter on his docket? What would be how would the jury pool, how would everyone that's following this case that's pro Baldoni, and they're very much on Baldoni's side, and rightfully so. He's a sympathetic person, and I'm on Baldoni's side. I like him. I feel compassion for him. I tend to lean on his side of the case, but I still want to call balls and strikes as I see them. But what if we reverse the situation? And this was Blake Lively's lawyers who had filed something that turned out to be really baseless and something the court found highly inappropriate to be filed. What would the uproar be on the Baldoni side as you see it?
Well, let me put this in a sports context. So you're a New Orleans Saints fan, right?
Except it's New Orleans, but yes, go ahead.
New Orleans, sorry. What's the primary rival team to the Saints?
Well, there's several of them, but we got the Atlanta Falcons, we got the Tampa Bay Buccaneers. Yeah.
Let's just take the Falcons. So you like the Saints, you don't like the Falcons. So what happens when something bad happens to the Falcons and they lose? You feel good, you like it. What happens when the Falcons win?
No, I'm a very noble fan, and I want the rules to be called the same way on both sides of it.
I mean, put yourself in the position of anything where you're, where you like one side and you don't like the other side. And so I think here, if it was Lively who filed something the way that Bryan Freedman did and the court struck it out the way the court did, and you can tell that Judge Lyman was not happy at all with Bryan Freedman's filing. I think people would say, here they are up to their old tricks again. Yeah. The fact that it happens on the Freedman side, you're a little bit more probably forgiving, but it just depends on what side you like.
I did see several podcasters that are very pro Baldoni every single time. They never say anything positive about the Lively team ever, not one time, and everything is Baldoni, and he's so wonderful. And they came out and said how this Lyman ruling was not that big of a deal, and it really is actually good news. I mean, it was all the things that sports fans would say when their team loses, and they say, well, it was the referees or the umpire or whatever the case may be. But I think there's something else we have to talk about, and that is the Samantha Katze filing and the Bryan Freedman letter filing. There's also the gravity of the conduct, whether it's unethical or not. There's a gravity to what's happening. And so let me ask you this. If either Samantha Katze or Bryan Freedman, and neither one has done this that we know of, openly went into court and lied to the judge's face, like over and over again, just outright lied to the judge on behalf of their client, is that something we get a little bit more excited about and say, now that truly is unethical conduct, and the court is going to punish the lawyer based on the gravity of that conduct. Would you agree with that assessment?
Yeah, absolutely. And that'd be something that we would have zero tolerance for as lawyers, because as lawyers, we are supposed to be officers of the court. And to go into court and lie to a judge, it's absolutely unacceptable on every level. So that's more clear cut.
So the filing of the Doe lawsuit, some people call it the sham lawsuit, the gravity there, I mean, if you're saying that they knew everything and they went ahead and did it and broke some rules, that's something the court would want to know and want to deal with. I don't know if it's the same as going in and lying to a judge in open court. And then Bryan Freedman's letter as well. It seems to me what the judge did here is he just publicly embarrassed Bryan Freedman with some fairly strong language that we're going to look at in his order. That was just embarrassing. And Bryan Freedman was, I think, trying to be a strong advocate for his clients, just like Samantha Katze was trying to be a strong advocate for her clients. And look, it's not always easy. Some of these calls are much easier than others. You don't lie to a judge. That's an easy call. You don't lie to a jury. Easy call. But when you get into like discovery, Keith, when we send written discovery to the opposing side, are we sending that to make them busy and give them heartaches and give them a hard time in responding to discovery? Or are we sending discovery to uncover facts for our case so that we can move forward? And so there's a delicate balance that's going on there, isn't there?
Yeah, of course. And you can do something and have two different reasons for doing it at the same time. So, of course, you serve discovery to uncover facts and lock people into their story. But you're also not disappointed that you're making the other side work and jump through the hoops. That's for certain. And No,
go ahead.
So, I mean, I think that you can do that. And when you think about what Bryan Freedman did, he files this letter with the court. And of course, the judge is not having it, not happy with it. But over the course of the overall litigation here, what does it really mean to Baldoni that this happened? That the fact that Freedman filed this and the court threw it out. What do you think is the effect for the overall case for Baldoni?
I think it's a slight embarrassment for Freedman. It's really a spank on the hand. And I think at the end of the day, if this case goes all the way to trial, the jury will never be told about this. And, the facts of the case will be presented to the jury, and the jury's going to make a determination. And I still believe that Baldoni has the better case here in defending himself against Blake Lively. I don't think he has a very good case for the defamation that he's brought against Lively, but we don't need to go into that today. But that has to do with 47.1 and some other issues that we've talked about. But as far as Baldoni goes, he's a very likable person. For whatever reason, Blake Lively, I've watched her in interviews. To me, she just doesn't seem very likable. I think she's trying to act a little bit like Ryan Reynolds, and I think it works for him. I think people find him funny and charismatic, or at least they did find him funny and charismatic before this case blew up. But I just don't know about the likability factor here. And if you remember in the Johnny Depp trial, Amber Heard was not likable, and Johnny Depp. I mean, who doesn't like Johnny Depp? He's one of the most likable guys on the planet. Very flawed individual, in my opinion, but he's very likable, and you'd love to have a beer with him or a glass of wine, and he'd probably have several with you. So, that's I think the likability factor is an issue in this case going forward.
But why would a judge only give a slap on the hand to Freedman for filing this? What do you think the judge is thinking here?
I think the judge is setting a precedent that don't mess with my docket. You guys are, getting close to this was really for public consumption. For the press to pick up and ride on, and for the content creators to jump on, and you're not going to use my docket for that. So don't do it again. And the court even said at the end of his order, he's like, look, you're not being monetarily sanctioned at this point, but I will do that if you keep doing this. So it was just, in my mind, the court was saying, don't do this. What were your thoughts on it, Keith?
Well, and I think judges know that attorneys are supposed to be zealous advocates. And I think that they know that sometimes they do stuff like this, and because they're trying to really represent and advocate for their client. And even though the judge can look at this and say, okay, this isn't appropriate, I'm striking this, the judge can also say, but I'm not going to punish you severely this time. I'm going to give you a warning, a slap on the hand. I am going to tell you if you do it again, there's going to be sanctions possibly. But, look, judges get it. They know the pressures and the duties that lawyers have.
All right, Keith, I wanted to throw up just briefly. This is the letter from Esra Hudson to the judge regarding the filing by Bryan Freedman. I don't think we need to. She just basically says, hey, this should be stricken from the record. This is inappropriate. So why don't we move right into the order of the judge? And you can see this is Judge Lyman's order, and it came fairly quickly. And he says, courts have inherent power to manage their own affairs so as to achieve the orderly, expeditious disposition of cases. This includes the power to strike materials outside the pleadings that are abusive or otherwise improper. He goes on to say the Second Circuit has emphasized that courts should protect the judicial process from being co-opted to promote scandal arising out of unproven, potentially libelous statements. And then, of course, he goes on to say down below, the letter from Bryan Freedman is improper and must be stricken. It is irrelevant to any issue before this court and does not request any action from this court. And then go ahead.
Can you look at the prior paragraph that you had highlighted just down from the highlighting? It's kind of interesting because they actually say that the court not only has the power, but also the responsibility to exercise supervisory power over its own records and files to ensure that they are not used to gratify private spite or promote public scandal or serve as reservoirs of libelous statements. So I think it's interesting how the court framed that as not just the power, but the responsibility.
Yeah, I think you're right. And then we get, Keith, to the spanking, the public spanking, the public shaming, whatever you want to call it. But I'll read this, and I want your comments on it. It concerns a subpoena proceeding in the District of Columbia over which the court has no authority. And here's that the judge does not hold back. Judge Lyman says the sole purpose of the letter is to promote public scandal by advancing inflammatory accusations on information and belief against Lively and her counsel. It transparently invites a press uproar by suggesting that Lively and her counsel attempted to extort a well-known celebrity. Retaining the letter on the docket would be of no use to the court and would allow the court's docket to serve as a reservoir of libelous statements for press consumption. And then the court didn't stop there, Keith. After he made those statements, on his own motion, even though Esra Hudson had not included this in her request, he strikes another filing by Bryan Freedman, and that was 219. So what are we going to take away from this court order? I mean, how do you feel? Do you feel this was the judge, did he make the right decision here? Was he hard enough? Was he too hard? What's your sense of this order?
No, I think the judge struck the right balance. I don't think he was too hard. I think they were filings that had nothing to do with anything. And so the fact that they were filed just the way that they were filed, I think the judge is within his rights to strike them. I think it was the appropriate thing to do. I think it was good for the judge not to issue sanctions and say, look, I'm just, going to do this, but issue everybody a warning, mainly Freedman, I guess. But it applies to everybody equally. I don't want to see this from either side. I was kind of surprised that the judge did it so rapidly. And it does show kind of the way federal judges operate, which is they don't really countenance a lot of playing around. I mean, they kind of run a tight ship. And stuff like this can happen in state courts. And, judges there will do stuff like this, but I don't feel like they have the ability to act so quickly, primarily probably because they're dealing with way more cases, just the volume of cases so much higher. But it is interesting to see, how this came about and how quickly the judge reacted. Now, if you were to take all of those facts that were filed by Freedman, would there be a proper way to use those facts in a court filing?
Potentially. And that's if those facts could come out in any other type of filing that had merit with this court. Now, he could do it in an amended complaint, perhaps. He could do it in a motion. There's been lots of people that talked about how unethical it was for Samantha Katze and Manatt to essentially file this Doe-only lawsuit. But it's been weeks since people have been talking about this. Is Bryan Freedman going to file something in the federal court and try to hold them accountable if he believes that it was unethical and wrong for them to file this Doe-only lawsuit? Is he holding this as something in his back pocket that he can play later down the road? But if you were to file something that the court could actually make a decision on here in the second district and it had something to do with this case, if you wanted to slip in some of those facts, you might get away with that. Rather than just simply sending this to the court saying, hey, I'm responding to this letter that the other side wrote. And, oh, by the way, there's these really interesting facts the court and the public may want to know about. And here it is. So I think there was a better way to do it. And again, I'm asking Bryan Freedman and anyone who thinks that the Doe-only lawsuit was such a sham and was such an unethical move, why hasn't Bryan Freedman done anything about that particular filing at this point in time?
I am a little surprised that they haven't. I think they should have been filing some sort of motion by now. At a very minimum, they should ask the court to exclude all of those text messages unless they're acquired through a proper subpoena with proper notice. And you would think that there would be some sort of motion on that. Now, it could be that they're working on it. It's not the easiest thing in the world to draft up some of these motions, especially when there are things that are a little bit novel. And so this situation is not something you come across every day. And so trying to do the research and put together the arguments once you encounter this novel situation, it can take time and it can be very in depth to put something like that together. So it's possible they're still working on it, but it would have been better for them to file a motion on that and then include facts about, what this filing had in support of that motion. Because then the filing would have had a purpose. I'm going to court on a motion. I want the court to rule on something. To file something just to file it, even though and the court doesn't have anything to do with it, that's where I think the judge said, okay, that crosses the line. We're not going to do that.
Well, and I also think that this source is going to come out either voluntarily or involuntarily sooner than later. That's been speaking to Bryan Freedman. And so then I'm assuming a deposition subpoena will be issued and by somebody, either side, and we'll find out more about what this person said. There's some, I think some people have said it might be, obviously probably an insider with Swift. It could be a relative of Swift's, a lawyer that's related to the case. I mean, so it will come out at some point, and then we can know more about it. But I think the point I want to point, I don't know if that's circular reasoning. What is that? The point I want to make is
that's from the Department of Redundancy Department.
Yeah, thank you. Isn't that the office or something like that? What the point I want to make here is that, look, these are hard decisions, and these lawyers on both sides, from my viewpoint, I have not seen unethical behavior. I've seen hard, zealous advocates working very hard for their clients. I've seen a lot of armchair quarterbacking being done by people online, and people are allowed to do that. The more the merrier. If people want to talk about this case, fine, talk about the case, but be willing to stand up for your position. I made a comment once to somebody who made a comment on the show here, and people called me out and said, "Oh, you can't! How dare you attack that person?" And I don't think I was attacking the person, but look, if you're going to walk into a bar and you're going to belly up to the bar and you're going to start throwing some opinions around, there's going to be other people that are at that bar and they're going to have some opinions too. So you have to take the good with the bad. And if you're willing to throw your opinions out there, fantastic. It's great. It's good for discussion. But other people may have a different view. And so there may be some logical arguments that go back and forth. Hopefully no fisticuffs, but people can argue these things out. This is hard stuff here. And people are making, Keith, we make decisions all the time in our cases. And they are hard decisions. And after the fact, we look back and we learn from those decisions many times. But we have more knowledge after the fact. We have better understanding after the fact. For example, Bryan Freedman now knows this judge does not like people messing with his docket. You think Bryan Freedman would file this letter had he known the response of the judge? Well, of course he wouldn't have filed it. But now that he knows,
so sure.
Oh no,
I'm not so sure.
You think he would have filed it?
Well, was it a mistake? I mean, he got the information out there in the public realm, and he got the information known, which is what he wanted, and then he got slapped by the judge. So I guess the question is, was it a mistake in hindsight, or was it not?
Right.
I don't know.
Well, I would say that if I was the lawyer and I filed something and got that response back from the judge, I would not feel good about that situation. I say, okay, right. I should not have filed that, and I won't make that mistake again. At least with this judge. Now, maybe with another judge, there could be other federal judges out there that maybe this is not a big deal. I think most federal judges are going to be fairly zealous of their docket, and they're not wanting people to unfairly use the process. And some people have pointed out it's very rich of Lively's attorneys to be filing motions to strike when they have their own behavior to look at, which people have pointed to the Van Zam Doe filing and the sham lawsuit, they're calling it. But again, Bryan Freedman has done nothing with the sham lawsuit. He has made no filing. He's made taken no strategic position with the court regarding that. And so until he does, I'm not sure how big a deal that really is at the end of the day.
Yeah. I mean, I would think that we're going to see something. I would expect to see something, but I am a little surprised that we haven't yet. But I would be really interested to see the deposition of whoever the insider was that knows about, this scenario that they're alleging, that apparently there was maybe some trying to intimidate witnesses going on. And that would be a deposition that you would want to set up immediately and get to the bottom of, because if you have evidence that you can bring into court showing that one of the parties tried to intimidate a witness, I mean, that's going to be very powerful evidence in front of a judge or a jury.
Yeah, no. And if this individual who's renamed unnamed at this point in time, if they have personal knowledge and it's credible, that will be a problem for Blake Lively. And so not only will Bryan Freedman have that to use, but he'll ostensibly have the Van Zan filing, which again, show us the people that are watching this case, if this was such an unethical thing, then obviously you need to move forward, because you just can't sit on that either. If you sit on that for months and months and months, and then you show up in court 6 months from now, the judge is going to be like, you've known about this for 6 months. Why are you just giving me a filing now? It's something you've got to move forward with, at least contemporaneously with the action that took place.
Yeah, I would think so too. And I'm a little surprised, although not entirely, that the judge hasn't ruled on the 12B6 motion to dismiss yet. But In fairness to the judge, there was a lot of them. There's at least 4 of them, and they were heavy duty motions. And so, it does take time to analyze and come out with a decision on all that.
Yep, absolutely. So Keith, the last thing we want to talk about, and then we'll take people's questions. I know Eric is busy starring some questions, but the last thing we wanted to talk about, just briefly, you don't need to spend a lot of time here, but, and there's some people that are just blown away by the idea that Blake Lively's attorneys are doing this. And this is, I think Michael Gottlieb is the one that drafted this. And this is a request for sanctions under Rule 11 against various plaintiffs and their lawyers on the Baldoni side. Now, it's not against Justin Baldoni, because apparently, the Lively lawyers are conceding that the claims made against him, they're at least valid claims made. Whether there are facts and witnesses to support those claims, that'll be seen at another time. But there's other plaintiffs here that don't have claims according to Blake Lively's attorneys. And so they've very soon, sooner than I thought they would, file a Rule 11 sanctions motion. And what are your thoughts on this motion, Keith?
Well, I have 2 thoughts. I mean, first of all, I think it's premature. So they have the motions to dismiss. The 12B6 are submitted. They're fully briefed. We're waiting for a ruling from the court. I think we need to see how the court rules on those motions first, because if the court denies those motions to dismiss, then I think it takes the winds out of the sail of this Rule 11 motion. Maybe we should. And secondly, I think the Rule 11 motion, I'm not sure that it's going to prevail on its own right, but maybe we should talk about what the Federal Rule of Civil Procedure 11, what duty it imposes. I don't know. Do you have that?
Yeah, I can pull that up. Yep, absolutely. Hang on here 1 second. Okay, so let me pull this up, the standard here. Let's just use the introduction. They do have a better standard later on, but why don't we just look at this, Keith? Go ahead.
Yeah, and I think on page 2 they have a really nice statement of it too. But really, it just imposes the duty.
There we go. Sorry about that.
Yeah, there it is. So it just imposes a duty on counsel to ensure any pleading or motion presented to the court is not frivolous, legally unreasonable, or factually without foundation, and is not being presented for any improper purposes, such as to harass, cause unnecessary delay, or needlessly increase cost of litigation. So you're talking about a truly frivolous action. The problem is, every party in every lawsuit thinks that the other side is filing a frivolous action. But every lawsuit at least has some factual allegations that take it out of the world of frivolity. It doesn't mean it's going to win, but there are some factual allegations. So here, what we're talking about, part of what we're talking about, is a defamation claim that Justin Baldoni brought against Ryan Reynolds. So Baldoni's suing Ryan Reynolds for the alleged statement that Ryan Reynolds said that Baldoni's a sexual predator. And he's saying, well, that goes to Baldoni, but that doesn't defame Sarowitz or Nathan or Abel or Heath, or It Ends With Us LLC. He might be right in terms of actually winning the lawsuit. He might be right. But in terms of actually filing a lawsuit and making allegations, I think it's good enough. And I think it's good enough to get it outside the world of what would normally be considered frivolous. I think frivolous is something where there's literally no facts whatsoever. And so if I were to sue you for breach of contract and we never met and we had no contract and I have no facts of a contract, that's frivolous. And so I don't think the Rule 11 motion has a good chance of succeeding, but yet here they are bringing it. Again, it's kind of goes back to your statement at the beginning of the show today of what's the difference between zealous advocacy and, maybe doing something that's inappropriate. I mean, this is, again, another example, I think, of zealous advocacy. But do you think the Rule 11 motion has a chance of winning? When you looked at it, were you persuaded or concerned about it?
So my ultimate response is this too early. It's too early at this stage. And I just don't, I think the court hasn't even ruled on the 12B6 motions. Discovery is they're still fighting over even responding to discovery. And generally, I think what Freedman's team is saying, and there's this safe harbor letters that went back and forth between the two sides before this Rule 11 sanctions motion can be filed. And it's a 21-day safe harbor, and the letters go back and forth. and Blake Lively's lawyers send letters to Baldoni's lawyer saying, you don't have any claims, you don't have any facts, you're not even close to facts, so you got to withdraw these or we're going to file this Rule 11 sanction motion. And then Baldoni's team, they're supposed to respond back. And a day before the 21 days ran, Baldoni's team, somebody from Bryan Freedman's office, did respond back, and they said, look, discovery is continuing, and we think we've pleaded claims that are sufficient, and we think that we're allowed to do further inquiries. And I think the one thing that hits me here, Keith, and I need to go back to sharing, there was one thing that really stood out to me. It's right here, and it's the legal standard, and it's a little bit they go into depth on the legal standard. And again, this is from Lively's own attorneys, and they're giving the Rule 11, and they give the reasons. And it's Rule 11 requires attorney to certify that the pleading or motion is, in good faith and not meant to hurt somebody just for hurting purposes, that the claims and defenses are warranted, blah, blah, blah. But I really think number 3 will help Baldoni's team and help Bryan Freedman, and that is the factual contentions have evidentiary support. Or, if so specifically identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And I think that's what Bryan Freedman's office responded to these safe harbor letters with. And that is, look, once we get through discovery, it's going to give us a better understanding of what this case is about and who said what, and when they said it, and who's been impacted by that. And of course, a lot of this could be cleaned up either in the 12B6s that the court still needs to decide, as you pointed out, or a Rule 56 motion for summary judgment could be filed. And that is where facts can actually be considered, so you can toss people out. And, judges, I think Judge Lyman, he sounds like a very smart guy to me. I don't know much about him other than what I've seen from his decision-making. He seems like a very serious, sober type of judge that calls balls and strikes closely to the rules. And I just have a hard time believing he's going to sanction somebody here this early, because I think the press would go bananas. I mean, content creators would go bananas. And I just don't think he's going to add fuel to the fire that way. I think what he's going to do is say, look, it's premature. If you want to file this in the future, feel free to do that, but I'm not going to grant it at this time. And why don't you guys continue your discovery fights? I know several motions have been filed on motions to compel regarding discovery. Let's get all that cleaned up. Let's get our depositions done. Let's get expert depositions done. Let's get closer to trial. And then if you want to file a Rule 11 sanction motion, be my guest.
Well, yeah, I mean, think about it. Let's say that the allegation that Ryan Reynolds called Baldoni a sexual predator, let's say that that's proven true and the jury decides that that's true. Does that hurt Baldoni? I would say so, right? He's the one who was talked about. Does it hurt It Ends With Us, LLC? Possibly. Yeah, it could be. I mean, Baldoni's attached to him. Does it hurt Sorowitz? Well, it could. I mean, we saw in the briefing that you can actually be part of a defamation claim if you're part of a group and it's understood that a statement is being defamatory towards that group. So arguably it could, and arguably a jury could find that Sorowitz was also harmed. So just in terms of a factual allegation that's being made in a complaint, I think it's enough to get outside of a Rule 11 problem. I think you've said enough to at least base the complaint. And then, like you said, do your discovery. We'll find out.
Yeah, and so I think that's ultimately what will happen here. We'll see, because the judge will have to rule along the lines here of either granting it in part, denying it in part. I mean, you don't like to see them. Judges do that a lot. I like to see them either say yes or no, give us a full order here. But again, Judge Lyman, I think, is a very sober, serious guy, and I don't think he's going to grant this at this time. He could, but I don't see him doing that. I think he's going to let this play out a little bit. And I think your points are well taken. Who are the people that are impacted by this? We don't know yet. Because what if Ryan Reynolds sits down for his deposition and says, not only did I say that Justin Baldoni was a sexual predator, but I said X, Y, and Z, and somehow or another those things can be related back to other people. I'm not saying he's going to say those things. I'm just saying, what if that were to happen? So, it's a little premature in my mind to be asking for Rule 11 sanctions at this time.
Yeah, so it looks like the Rule 11 probably will not be harmful to the Baldoni parties. It looks like even though Bryan Freedman's letters were stricken by the judge, it looks like there's really no lasting harm on that. It was a hand slap. And so no harm, no foul there. And now the big question mark is, what's Baldoni going to do, or Freedman going to do, about the subpoenas, the subpoenas that were issued, number one. And number two, what's the court going to do on these motions to dismiss? Those are the two things that I'm really waiting to see.
Yeah, I think those are the big things. And by the way, Judge Lyman, I did hear, some people, and look, these are the minority of people, but I think the jury pool should know this. There's the loud minority, and they're like 2% of the people, and they're just so loud and obnoxious, and everybody thinks, oh, that must be what everybody thinks. And people were talking about how the judge was bought off when he did this order to strike the letter, and that the judge, has a brother that's in the entertainment industry. Look, I think Judge Lyman, I haven't done a lot of background check on it. He's a federal judge. I don't think there's any problem with this judge making orders and rulings in this case or any other case that he has on his docket. And I would, I don't think that these people saying that he's being bought off, I don't think that's responsible, number one. And I think that the 88% of the rest of the world out there watching this should know these are just loud, obnoxious people that are not hearing it their way. And so they're going to say anything that makes them feel good about it. I think the majority of people understand that most federal judges, I think there's 600 or 700 of them appointed across the country. These are some of the most successful people, smartest people, not saying that, they don't have their prejudices and biases, but I find it hard to believe that any of them could ever be bought off.
Well, Judge Lyman's the same judge that shut down the subpoenas that Lively wanted to issue that were too broad against Justin Baldoni and the Wayfair parties. So, you can't have it both ways. You like when the judge makes a ruling that shuts down that subpoena, which is a good ruling, is an appropriate ruling, and he did a great job on it. But then you don't like the judge when he strikes these filings by Freedman, which quite frankly were filings that were not attached to a motion or anything. So they were properly stricken from the record. But that doesn't mean that Freedman can't use those facts in the future, especially once he gets the deposition of whoever the informant is. And it doesn't mean he can't use it at time of trial. So, I would just say, look, there's more to come. It's kind of funny too, like the jury does not see what's in the court record, right? Will the jury ever see all of these filings that we're talking about?
They shouldn't. No, and they shouldn't.
Yeah, because it's all hearsay. So everybody's up in arms over the filings. Look, that's not the trial. The trial is the trial. In the trial, they're only going to see the admissible evidence that the judge allows in. And we can all sit here and argue about these things that are being filed. But anyway, it is kind of funny how you can get mad at Judge Lyman for striking what Freedman filed, but it's the same judge that you liked back when they shut down those subpoenas, and rightly so. He did a great job on those subpoenas.
All right. Well, producer Eric, do we have any questions, or is it a slow day today?
No, there's a lot of great comments in here. This was one, I know you guys were kind of talking about it, but if you wanted to add anything else, feel free. Gigi wanted to know, is it premature to file for sanctions when judge hasn't ruled on the motion to dismiss? You guys talked about it, but figured I'd let you add anything else.
Well, I think we can emphasize it a bit more. Keith, what are your thoughts? Is it premature, or would this be better to file, after discovery is completed?
Yeah, I think it's definitely premature. It's not only premature before the judge rules on the motions to dismiss, but it's definitely premature before the discovery is complete as well. So there's, I guess, two different things that need to happen before they even consider a Rule 11. And I don't think judges take the Rule 11 motion like this all that seriously, because I think, again, judges know that the lawyers are being zealous advocates.
And I would say I agree with something you said earlier too, Keith, and that is when we're in a case and when we believe in our clients and we're fighting for our clients, sometimes we think the other side is just evil and they're just doing horrible things, when it's just because we're very passionate about our view of the case. And sometimes we're surprised when a judge rules against us on a particular issue, because we're like, how can a judge rule against us? We're so right. And that's because they're an independent person and they don't see it exactly the same way we do. We're advocates. We're fighting on behalf of our client. Young lawyers ask me, how do you become a good trial litigator? And I say, well, it's a little bit like being a doctor, where you're trying to save a patient's life by taking out their appendicitis that's exploded. And you have a doctor on the other side of you trying to preclude you from doing that surgery. Right. That's what a litigation is. It's a fight. It's a dog fight. It's a gladiator fight. And, it's who knows how to move the chess pieces the best. And ultimately, at the end of the day, you just have to have tough skin, because judges are going to there's been times where we've been at trial, Keith, and we've worked a year and a half, 3 years, whatever it is, and we have one piece of evidence that we just think is a slam dunk that's going to just totally, win this case for us. And when we try to introduce that piece of evidence, the judge isn't persuaded and goes, "No, I'm not going to introduce it." And you're like, "How can you not? This is my whole case, Judge. You gotta let this evidence come in." And of course, then you have to start looking at you have to go to Plan B to continue prosecuting the case.
Yeah. Anytime a judge rules against me on a motion, I always think the judge was wrong. I don't think I've ever thought the judge was right. But that's the nature of being an advocate.
Here's one. KS wants to know, I want to know why Keith and Stewart think the judge is not ruling yet.
Oh, well, that's an interesting question. Let's see if Stewart can get inside the mind of a judge. So why is the judge not ruling yet, Stewart?
Federal judges can take as much time as they want on these. You and I used to chase cases up to federal court and try to get them remanded back to state court on some mass tort issues we were working on back in the day. And some of the judges were really quick. Some of the magistrates were even faster to rule on our motions. And in many cases, they wouldn't even have oral argument like we do in state court. But the judge, he can take his time, and he wants to get this right. He's got staff that are helping him. He's got other cases he's working on as well. So he wants to get this right. And I'm assuming we're going to have something not too far in the distance on some of these 12B6s. If I was the judge, I would hit the New York Times one first, get that completed, and then you can look at some of the others. But I'm not the judge. So, he has a view of it. His staff has a view of it. And we'll hear from him when he's ready for us to hear from him.
And do you think, Stewart, when the judge is ruling on things like this, are they thinking about the appellate court and whether or not their decisions are going to be appealed? Does that have any effect on kind of how the time they take or the research they do?
That's a really interesting question, Keith, because you would assume that judges really care, trial judges really care about not being overturned on appeal, because it's a matter of personal pride. You made a decision, you don't want to be overturned. But, I've talked to some state court judges, not federal court judges, and they've taken the position, I don't care if I get overturned. This is the position. This is how I view it. And this is the decision I'm going to make. Now, is that true? I mean, if I made a decision as a judge, I wouldn't want to have some public decision with my name on it saying that I was overturned. So I has to have some impact on some judges, maybe the majority of judges, but some trial judges, at least in state court that I've spoken to, it doesn't seem to be a big impact, at least from what they're telling me. Maybe deep down inside, they care.
Do you think the bigger issue for most judges is they want to get it right as far as they're concerned?
Yeah, I think judges make decisions like people make decisions. You want to feel good about the decision. You want your stomach to feel good about it, and then you back yourself into the analysis. So you don't analyze first and make the hard decision. You actually want to say, hey, I want to make the right decision here. And is there a law out there that allows me to make that right decision? I don't think judges would tell you that out loud, but I think that's how judges make decisions.
Yeah.
Okay. What's next here? This was in reference to, the Freedman's response, lose upon gain an advantage. I don't know.
Oh, I don't know either, but Stewart does. He's our chess master, so he can tell us all about that.
Yeah. So that's the idea. There is that you lose a pawn early in the game, and then the other side thinks they're up, but you've really strategically you've advanced your opening, you've advanced your development, and you overwhelm the other side. It's called a gambit. And so gambits have been around. I'm assuming Napoleon did gambits. Alexander the Great did gambits. It's an idea of pushing your forces forward and then pulling them back at the last second and then hitting from the sides or something along those lines. And people do it all the time.
Yeah, wrist slap is a pawn loss. Here we go. What else? Do you guys think that they're doing all of these filings to try and settle? Do you think there's a chance they will settle?
So Keith, the two questions there. And the first is, is Lively just trying to put a lot of force and uncomfortability on the other side right now to get them into the mediation room to resolve this? What do you think?
Could be. It's not an uncommon strategy to kind of, carry a big stick. What is it? Talk softly, but carry a big stick.
Teddy Roosevelt. Yeah.
Teddy Roosevelt.
Yeah. So it could be that they're trying to do a number of filings and, just be very active, but then behind the scenes want to try to get to a settlement. And that does happen in cases from time to time. It's not necessarily the best strategy in every case, but it could be a strategy that they're employing. I don't know. I mean, I kind of feel like, especially after the whole motion to dismiss by Ryan Reynolds, that the gloves really came off by both sides and they've just been duking it out. So I don't feel like these filings are necessarily designed to try and get a settlement. But I don't know. What do you think, Stuart?
Well, before I answer that, the second part of that question was, do you think the case will settle?
It will. I mean, I can't say that with 100% certainty, but look, every case has the possibility of settling. And there's always terms upon which people can settle. And I know it seems impossible, and everybody's going to say there's no way it can settle, and there's no way Justin Baldoni could agree to a settlement. He could agree to a settlement. There is a way, and I don't know what that way is necessarily. I can't sit here and specify exactly what it would be. Obviously, it would have to be something that satisfies the things that he feels that he has gone through, whether that's money, whether that's an apology or a public statement. I don't know. But every case has the potential of settling, believe it or not. And I know that's hard to believe, but it's possible. Will this one settle? There was a time when I think I felt like the chances were very high. And now I feel like the chances are much lower because, again, I think the gloves have come off and people have really started to dig in. And that bodes ill for settling, but not impossible. Nothing's impossible when it comes to settling.
Yeah, this was a good point by Jordan. They say, Justin is a Baha'i and he is always open to forgiveness and resolution. So could be a good point. A couple people were commenting about Ron Zambrano. So maybe we should chat with him again sometime soon. I don't think Ron has a YouTube page, but I could be wrong.
I think his firm does have a page and he puts up, all of his appearances. And I really like Ron a lot. I think he's one of the sharpest lawyers we've talked to on this case. He's on with Popcorn Planet, I think, more times than not. But really appreciate Ron and his comments on this case.
Yeah, we'd love to have him on again at some point.
Sorry.
But I want to go back because I want Stuart's opinion on, do you think that all of these filings are being done for the purpose of trying to get a settlement?
I think these filings right now are mostly based on emotion and based on mutually assured destruction. And, I think both sides are fighting very hard. I think that you've got more pressures in this type of case because it's not just a case in the courtroom, it's in the court of public perception and opinion. And so Bryan Freedman I think that's why he filed the letter. But yeah, this is tough. And these guys are fighting very hard. And so I think the combatants are like in any war, they're fighting, they're doing their job. And I think they're doing it from a zealous advocacy standpoint. And I think they're doing what they can to help their client win or their clients win. As far as the case settling, the statistics tell us that 96 to 98% of cases settle. Obviously, Amber Heard and Johnny Depp case went forward. O.J. Simpson is a case that goes forward. That's criminal, but that's still those cases settle too. I think that the odds are that this case will settle. I think the expense involved, the millions and millions and millions of dollars in attorney's fees on both sides already spent, and it's just getting started. That will not stop. Keith, you worked at big firms in Los Angeles when you first started practicing. How many lawyers do you think that Manatt is throwing at this case for Blake Lively and Ryan Reynolds? And how many lawyers is Bryan Freedman and his firm throwing at this? It's got to be a tremendous amount of resources being put in by both sides.
Yeah, there's probably dozens on both sides. I mean, you're in the millions and millions of dollars by both sides. Each side has spent, millions, not 1 million, but multiple millions at this point.
Yeah.
Someone had that question earlier. Yeah.
Sorry, Eric, I'll just jump in here. I think this case should settle. And I would encourage, again, there needs to be a lawyer on the Baldoni side, and there needs to be a lawyer on the Lively side and Reynolds side. And those two lawyers need to go and have dinner together and not talk about this case at all for 2 or 3 dinners and just get to know each other and talk about kids and family and build a relationship and start talking about, at the 4th dinner, how are we going to resolve this case? Because it seems impossible to resolve. And Keith, as you know, all of our cases are impossible to resolve. Clients always say, I'll never settle. The other side says they won't settle. Lawyers say they won't settle. But if you can get 2 lawyers or 3 or 4 lawyers, whatever it is, to start to get to know one another and trust one another and realize, I'm not trying to screw you. I'm not trying to harm you in this settlement, but hey, how can we work together collaboratively to resolve this case? That needs to be happening. And I don't know if it is or not, but let the combatants continue to be combatants. Let them fight. Let them do their job as gladiators. But there needs to be some diplomats for both sides that are meeting and at least discussing how can we resolve this on behalf of our clients. And maybe it doesn't resolve today. Maybe there still needs to be more bloodletting. You and I call it poking each, we tell our clients, you got to keep poking the other side in the nose, and they keep poking you in the nose. After you get poked in the nose like 1,000 times, you go, okay, that's enough for me. How do I stop getting poked in the nose? Well, you got to resolve the case. That's what you do. And so both sides reluctantly go to a mediation. And this would be a very complex mediation for these parties. But I think with the quality of lawyers they have on both sides, and hopefully some diplomats that are there that know each other and can kind of trust each other in the discussions of settlement, that can hopefully get this case resolved for both sides.
I'm just glad you said no's. I wasn't sure where you were heading with the poking thing.
Well, and one other thing I'd say is if this case doesn't settle, I think it'll be some of the best legal education for young lawyers, for people going to law school, for people that are thinking about going to law school. This is going to be very rich. You're going to see every motion on the planet that gets filed in cases. And this would be a good exercise to watch and learn, for future reference.
For sure.
I thought this was an interesting question, and maybe you guys have studied some cases over the years, but, is there a common thread in cases that do go to trial?
Is there a common thread? Keith, I'm not sure what that question means. Do you understand it?
Yeah, well, I don't know. I mean, I think I can interpret it this way, which is there's an old saying in the law that when a case goes to trial, it's because one of the sides didn't evaluate the case properly. And so that's, and that's actually a fairly true statement. That's probably pretty accurate. And so the cases that go to trial, the ones where one side miscalculated. And the problem with most trials is it's winner take all. And so somebody's going to be very happy and somebody's going to be very, very upset. And with settlements, you can vary that. So with a settlement, you can make it so that everybody gets a little something and they're in control of it. So did you have an opinion on that, Stuart?
No. I think you nailed it. I think it could be a failure of both sides to evaluate the case, but certainly there's one side that's failed to evaluate it. Again, this case, the problem with it is it's a public issue and everyone's watching it. And, people want catharsis. People want to, people are really impacted by this case emotionally for various reasons. And so a lot of people have a vested interest in seeing this case go to trial. Obviously, the parties are the ones that have to pay for it, and they're the ones that really have to go through the emotional ups and downs. But there's so many people that want to see this case go to trial. Is that pressure there on these lawyers to take it to trial because that's there? And of course, if you don't take it to trial, if you're Bryan Freedman, then are people going to say, well, you didn't have a backbone and you're not a very good lawyer. You told us you were a good lawyer and you weren't willing to take it to trial. So Bryan Freedman might say, hey, I'm taking it to trial. So we'll have to see how it plays out.
Yeah.
Okay, maybe we can end on this one. This is a good question from Ania. What's your personal line when clients push your boundaries and you're crossing them? As in, how do you guys deal with it?
Like ethical boundaries, I imagine.
Yeah.
What do you think, Keith? If you have a client that asks us if we know they're going to lie and we're going to put them on the stand, are you willing to help them lie to the tribunal so that they can win their case?
No. And so that would be unethical and I wouldn't do that. Neither one of us would do that. But I think that's where you have to work with clients and you have to show them that the problem with getting on the stand and lying is that 9 times out of 10, the other side is going to be able to show some inconsistencies in your testimony and you're going to look terrible. And therefore, you're going to lose your case. So rather than lying, why don't we sit down and think about ways that you can testify truthfully that will be helpful for your case and not in a way that is just going to destroy your case. Juries hate liars. They hate the cover-up. The cover-up is always worse than the crime. And if you start going down that road, you're going to get completely obliterated. And that's true in front of the court too. I mean, not only is it unethical to lie to a judge, but it also destroys your credibility. And if you have no credibility in front of the judge, then your arguments aren't going to be very persuasive. They're not going to carry any weight. I mean, there's a method to our madness here. So being ethical is important to do for its own sake, but it's also important to do for winning a case. And so typically, I mean, I guess our go-to line is different with every client, and it depends on the situation. If a client just absolutely insists that we do something that's unethical, our line would be, we're just not going to do that. That's not something that we're willing to do. I don't think I've ever had that happen where a client absolutely insists that we do something unethical. But if that were to happen, we would just decline. I think the bigger issue is just working with clients so they can see a better path forward. And that's where you have to get a little creative sometimes, I think. I don't know. Do you have a go-to line, Stuart, that you use with clients?
I've never had a client ask me to help them lie. Of course, I hope and I believe that I would say, no, I'm not going to help you do that. But I do have clients that, come forward and say, hey, we should do this or that on the case, and it's not a good idea. And so you have to sit there and explain why it's not a good idea. And sometimes they just want a junkyard dog. That's what I get more often than not when we're doing an intake, Keith. They want to punish the other side, and we have to make very clear, look, ethically, we as lawyers are not here to punish the other side. Now, if they're punished in the process, that doesn't bother us. But our job and goal is not to punish the other side by doing things to them. Our job is to represent our client zealously. Our job is to get facts that support our client's claim and to win within the bounds of the rules that we're given as lawyers. That's what we're required to do. And so we're not going to be just junkyard dogs barking at the other side. We're actually trying to do the best we can for our clients within the bounds of the law. So that's what's going on there. I will say I've read, again, I have to stop reading the comments, but I did read comments where I had suggested that the Doe-only lawsuit, there is a version of that where it would be a good chess move, and I was called the most unethical lawyer on the planet. So I guess maybe I am an unethical lawyer, Keith, and so I need to watch that a little closer.
Well, I don't think you're unethical in the least, but it is interesting how it is subject to debate, right? So people can argue about these things, and it's so much easier to see in hindsight, even like what you said about Bryan Freedman's filing. So now Bryan Freedman can see that, oh, that wasn't a good idea. I made the judge angry. But on the other hand, maybe Bryan Freedman says, I don't care about making the judge angry on this one. I'm happy to do it because I wanted this information to get out in the public, and this is the best way for me to do it. I don't know. But everything's easier to figure out in hindsight. It's 2020.
So. Yes, I wish I could make all my investments based on hindsight. But
yes.
Hey, Keith, one thing I want to say too is that I've kept one of my eyes. I'm like the guy from the Western, that has one eye going one way on the comments. And I truly appreciate everybody in the jury pool. And by the way, I appreciate everybody that takes the time to comment. But certainly, I'm human. You're human, Keith. The ones that are so supportive and appreciate that we're back and have missed us. Thank you so much. We are, we wish we could be here more. But we are super busy. But certainly when the 12B6s are decided, you can bet we'll be here going through all those with you and giving you our straight opinions on those. But thank you so much for your kind comments. Thank you for all your comments, but the kind ones, I like those more. And we certainly look forward to continuing to cover this case and others.
Yeah, thank you, everybody at the jury pool, and thanks for showing up and engaging.
I like this question or this comment too. Someone said, they're canceling all their meetings. I need to watch this live. So I'm glad everyone could join.
Totally flattered. Serendipity 14. Thank you.
See, now that's somebody has their priorities straight right there.
Exactly. All right. Well, thanks everyone for joining.
All right. We'll see you guys next time.
Have a great day.
We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.